So should I start over?
Yes.
Yeah, but didn't record.
Okay, sorry. Okay.
Is the recording now?
This hearing is called to order. The date is June 4th, 2026, and the time is 1:06 p.m. And we're convened in the city of Walsenburg City Hall, 525 South Albert Avenue, Walsenburg, Colorado. I'm Gina Nigro, Deputy City Clerk of Walsenburg, and I've been designated as a hearing officer for this proceeding pursuant to CRS 3111-110-3. Sitting with me is Dan Hyatt, City of Walsenburg City Attorney, who's assisting me. This is a formal protest hearing concerning an initiated municipal petition proposing an ordinance amending sections 16-4-700 and 16-4-720 of the Walsenburg Municipal Code relating to the Criminal Detention Center CDC zoning district. The hearing is being recorded using Zoom video recording, and the recording will be preserved as part of the official record. I'll ask the parties to identify themselves for the record. Mr. Bryant, if you could please state your name and address.
Charles R. Bryant, 230 West 4th Street, Walsenburg, Colorado.
Thanks, Mr. Bryant. And Ms. Connell and Mr. Connell?
Connell, 215 West 3rd Street in Walsenburg, Colorado, 81089.
Daniel Connell, 215 West 3rd Street, Walsenburg, Colorado.
Thank you. Are there any other persons appearing today in representative or interested capacity? Okay. Before we begin, I want to establish the legal scope of this proceeding. This hearing is governed by CRS 3111-110, and my authority as the hearing officer is limited to determining whether this initiative petition meets the procedural requirements of Article 11 of Title 31. That is whether the petition is legally sufficient for certification and placement on the ballot. I'm not a court. I have no authority to conduct a constitutional review, evaluate the substantive policy merits or the proposed ordinance, or adjudicate claims of federal preemption or property rights, or deny ballot access on grounds outside the statutory framework of Article 11. Under CRS 3111-110-3, testimony in this hearing shall be under oath, and I have the power to issue subpoenas to compel the attendance of witnesses, and I will administer the oath to each witness before they testify. While I will receive written or sworn testimony, I want to be clear that my authority to act on that testimony is limited to the findings that are relevant to Article 11, petition sufficiency. Testimony going solely to the policy merits of the ordinance, its constitutional validity, or matters outside the scope of Article 11 will not form the basis of any finding in my written ruling. Regarding the procedural structure of today's hearing, there's a pending motion filed by Daniel Connell and Lakota Connell, a motion to limit testimony, strike improper argument, and dismiss the protest. I will hear argument on that motion today as the first order of business, and I'll take the motion under advisement and issue a single written ruling resolving both the motion and the protest simultaneously within 5 calendar days of the conclusion of this hearing as required by CRS 3111-110. Are there any questions about the scope and format of this hearing before we proceed? Hearing none. Before we proceed to argument and testimony, I want to give the parties and any witnesses some important instructions. First, all testimony in this hearing must be given under oath. I will administer the oath to each witness individually before they testify. It is unlawful to give false testimony under oath. Second, witnesses should speak clearly and answer the questions that is asked directly, and their answers to me as the hearing officer rather than the opposing party or the representative. The only person who may speak only one person may speak at a time. If one of the parties wishes to object to the relevance of the testimony, please wait for the witness to finish and then finish the answer and then address your objection to me. Fourth, as I noted, in the scope of the statement, in the statement scope, the purpose of this hearing is to determine whether the petition meets the legal requirements of Article 11, Title 31. Testimony should therefore be directed to that question, specifically whether the petition form and the content satisfy the requirements of CRS 3111-106, titled Form of Petition Sections and related provisions. I will not receive and I will not rely upon testimony that goes solely to the property merits of the proposed ordinance, its wisdom or the prudence as a matter of municipal government. Governance, or that belongs before a court.
I'll prepare a written statement that I would ask to be included in the record.
Oh, yes, ma'am. We'll get to that here shortly. Sixth, I may ask questions of any witness at that time. If I ask a question, please just answer it directly. Finally, witnesses who have not yet testified should not discuss the subject matter of the hearing with other witnesses who have not yet testified in order to preserve the integrity of the record. Does either party have questions about these witness instructions? Okay, so the documents that we have on the record, the following documents are part of the official record of this hearing, and I'm confirming their inclusion now. So if you'll just check and make sure that you'll have an opportunity to disagree here. The Exhibit A, which is the initiated petition, including full text of the proposed ordinance, the city prepared initiative summary, and the circulator of affidavit form. Exhibit B is the notice of protest filed by Charles R. Bryant. Exhibit C is the verified formal protest to the initiated municipal petition filed by Charles R. Bryant dated May 26, 2026, notarized in Huerfano County, Colorado. Exhibit D is the actual notice of protest. Exhibit E is the motion to limit testimony, strike improper arguments, and dismiss the protest filed, and it's been filed by Daniel Connell and Lakota Connell as petition proponents, notarized June 2nd, 2026. Are there any objections to the inclusion of any of these documents in the record? Are there any additional documents either party wishes to submit for the record at this time? Okay, great. If so, you want Rosie, could you grab that? Additional documents either party wishes to submit. If so, please identify this document for me, Ms. Connell. I'm sorry, I can't. Would you like to step up to the lectern? Okay.
This is a statement in opposition of the protest in its entirety of what we are speaking.
Exhibit F.
This will be marked as Exhibit F and entered into the record. The statement in opposition to protest. Thank you for that. We'll now hear argument on the motion filed by Daniel Connell and Lakota Connell. And as I noted, I'm taking the motion under advisement and will resolve it in my written ruling together with the protest. Today's argument is just for the purpose of completing the record. The motion asks to strike all 7 protest grounds as outside the statutory scope of this hearing, dismiss the protest in its entirety, and allow the petition to proceed to signature sufficiency review and the ballot certification. I'll hear from Daniel Connell and Lakota Connell first as the moving party, then from Charles R. Bryant in response, then from the Connells in a brief reply. Either party may call witnesses during this phase if they wish. and any witnesses called must be sworn before testifying. And I ask that the argument and testimony be focused on the legal question of whether each protest ground identifies a cognizable Article 11 petition defect. Witnesses are not parties in this matter and may not ask questions of the parties or of their witnesses. Daniel Connell and Lakota Connell, you may present your argument and any witness testimony to support the motion. And if you'd like to come up to the podium, I'll be happy to swear you in. And if you could state your name and spell your last name, please.
Lakota Connell, and last name is Connell.
And please raise your right hand. Do you swear or affirm in the testimony you are about to give in the proceeding is the truth, the whole truth, and nothing but the truth under penalty of law?
Yes, ma'am.
You have been sworn in.
I think they need to start out the meetings
And
like
you may
that, but ask
proceed.
the board that
The
question.
protest by Mr. Bryant raises no valid grounds under.
That would be an ultimate fail for him.
110. The city clerk's authority is limited to petition, circulatory affidavits, signature sufficiency, and Article 11 compliance. I'd like to make the motion to strike, but. if
Mark
it
needs
will
to
not
stop
be
moving
stricken,
around the
then
room. He's a
I'd
distraction.
like to again assert the protest identifies no defects in petition form, no defects in circulatory affidavits, no signature challenges, and no Article 11 violations. Currently, the protest raises only policy, constitutional, and zoning philosophy arguments, none of which are grounds for protest. Mr. Bryant's complaints is pressuring the clerk to exceed their purview under the statute. Our initiative is legislative, not administrative. It is valid zoning text amendment. Our initiative contains no Article 11 defects and is entitled to proceed to the ballot once the signatures are sufficient. Therefore, the protest in its current writing is fatally defective.
Thank you. Mr. Bryant, you may respond to that motion. And, oh, I'm sorry. I'm sorry, Mr. Connell. You could state your name and spell it for the record.
Daniel Connell.
And spell it, please.
Last name Connell.
Thank you. If you would raise your right hand. Do you swear and affirm that the testimony you are about to give in this proceeding is the truth, the whole truth, and nothing but the truth under penalty of law?
Yes.
Sir, you may proceed.
Under CRS 31-11-106 and 31-11-110. Petition form, circulator affidavits, signature sufficiency, and Article 11 compliance. What a protest may not challenge is zoning policy, federal preemption, constitutional vagueness, takings or vested rights, litigation risks, traditional planning process, ballot clarity, single subject concerns, or whether the initiative is good policy. The intent of those statutes are clear. A complaint should only consider administrative defects, and the city found none. Mr. Bryant's protests are outside the scope of this municipal hearing and law. Thank you.
Thank you, sir. Mr. Bryant? You could please state your name and spell it for the record, sir?
Yes, ma'am, and thank you for allowing me to speak with you all today. Charles Bryant, CharlesBryant.
All right, Mr. Bryant, if you'll raise your right hand. Do you swear or affirm that the testimony you are about to give in this proceeding is the truth, the whole truth, and nothing but the truth under penalty of law?
Yes.
Thank you, sir. You may proceed.
Yes, ma'am. My response to the motion to dismiss, when we look at the actual language contained in 31-11-110, section 1 to be specific, and if I may, then 40 days after an initiative or referendum petition is filed, a protest in writing under oath may be filed in the office of the clerk by any registered elector who resides in the municipality, setting forth specifically the grounds for such protest. The grounds for the protest may include but shall not be limited to the failure of any portion of petition or circulator affidavit to meet the requirements of this article. With that being said, there's been a few comments earlier claiming that we're reviewing and concerns listed in the protest actually go to that key theme as far as the administratability and practical application of this ordinance in its current format. And with that, I'll yield my time.
Thank you, sir. And at this time, if are no witnesses or representatives to step forward, that time has passed.
I'm curious, is Dan sitting up on the dais?
Daniel and Lakota, would you like a brief reply?
Yes.
Thanks, Ms. Connell. If you'll step up to the podium, please. And I'll remind you that you're under oath.
So under CRS 3111-106, it says required by this article, the protest must contain no extraneous material. The clerk may reject a petition or a section of a petition on the grounds that the petition or a section of the petition does not propose municipal legislation pursuant of the section 1(9) of Article V on the state constitution, of the state constitution. So what is in Article 11 has to be germane. It needs to be germane to those four things, which again would be the circulatory affidavit, signature certificate, and Article 11 compliance. So,
Mr. Connell, would you like to speak? All right, sir. Thank you. This motion will be taken under advisement and I'll resolve it in my written ruling along with the protest grounds. We'll now proceed to argument and testimony on the protest grounds. We'll now hear argument and sworn testimony on each of the 7 protest grounds raised by Mr. Bryant's verified petition or protest, I'm sorry. I will call each ground in turn. Mr. Bryant will present first, followed by the Connells' response and a brief reply from Mr. Bryant if needed. Either party may call witnesses on any ground. Any witness called must be sworn before testifying using the oath I administered earlier, or I will re-administer the oath if the witness has not previously been sworn into the proceedings. And remember, witnesses are not parties to this matter and may not ask questions of the parties or other witnesses. The Connells may not object or may note objections to any ground as outside the scope of Article 11. Those objections are preserved by the pending motion and will be addressed within the written ruling. I ask that the objections be stated briefly so the argument and testimony on each ground can be completed efficiently. So, Mr. Bryant, we have the first ground, the single subject aggregation of district policy objectives. Mr. Bryant, please present your argument and any testimony on ground A.
Sure. Would you like for me to step to the?
Yes, sir, if you don't mind.
Absent a city charter, as we of course are a statutory city, a lot of our operations here as a municipality, a statutory municipality, closely reflect those within state statute. And within state statute, as per the issue that I raised here, it's prohibited to have multiple ballot items on one ballot, multiple considerations, really to the fact that the term often used is log rolling. It creates an impracticality where voting citizens may be in agreement with one provision of the ballot, but not necessarily the other. That's really the basis of that particular argument. And for expedience, I really have nothing additional to add beyond that, which is in the written record presented to you in my protest.
Thank you so much. Lakota Connell, we'll start with you. And I'll remind you, you're under oath.
I will be the one doing the arguments.
Okay, perfect. Thank you so much.
Colorado municipal initiatives are not subject to single subject rule. Even if they were, the initiative has one subject, land use regulation in the CDCs. This is a policy argument and not a protest ground.
Thank you. Any brief reply, Mr. Bryant?
Not at this time. Thank you.
Thank you. Round A is submitted.
Don't forget you have to ask Daniel too.
Oh, I'm sorry, Lakota, we do have to ask Daniel if he would like to speak as well, because he's on the petition. Mr. Cannell, are you good? Okay. Ground A is submitted. Ground B, vagueness, and an administratively unworkable standards. Mr. Bryant, please present any testimony on ground B, and you're under oath.
Yes, thank you. This is perhaps one of the most concerning topics within my protest. When we look at the impermissibly vague and administratively unworkable standards, I try to put myself in the position as a city employee or administrator trying to effectively execute the provisions of this ordinance should it be passed by the voters. And with that, there seems to be some extreme difficulties deciding how exactly such would be implemented, especially when we look at the rather vague and ambiguous definitions. For the sake of distraction, do you mind?
Yeah, no, not at all. Sorry.
Back to my point, when we look at
Take your time, sir.
the standards or the lack of definition on key elements within the proposed ordinance, that would really demand scrutiny. In particular, the term immigrant is used with no definition of supplied within the draft ordinance and can be construed in many different ways. When you look at the definition of immigrant, the questions that I hope the city asks themselves in their deliberations in the 5 days after our hearing today, what does immigrant mean under this ordinance? How would the city determine whether a particular inmate falls within that definition? What information source would be used? Does the city have access to such an information source? How would the city verify that information provided should it be available? How would the city keep those determinations current? And what municipal mechanisms exist to determine whether the ordinance is being followed? I respectfully submit that municipal ordinances ultimately require consistent administrative procedures for implementation and enforcement. My concern is that it remains unclear what procedures could be developed here without first resolving the definitional and compliance questions identified in the protest. The ordinance appears to impose a requirement, but it remains unclear how the city would define the covered population, determine compliance, verify compliance, and enforce compliance. With that being said, I'll yield my time.
Thank you, sir. Lakota Connell? You're under oath.
Vagueness is a constitutional argument, not a protest ground. The ordinance regulates facility use, not people. Zoning routinely uses broad categories, for example, group home or detention facility. Enforcement requires only determining whether a facility is used for federal immigrant detention, not classifying the individuals themselves.
Thank you. And Mr. Connell, do you wish to speak?
No, thank you.
Thank you, sir. Mr. Bryant, would you like a brief retort?
Just a short one. Well, it's been conveyed by the petitioners in their public outreach efforts concerning the passage of this proposed ordinance for it to be really targeted towards the ongoing ICE enforcement activity. As worded, it could easily be construed that it limits routine incarceration. When we look at our inmate populations here in the United States, it's a multitude of folks of different nationalities and backgrounds. So while it might be geared towards immigration, it would certainly have off-target effects, which I will be discussing additionally here in a few. Thank you.
Thank you, sir. Ground B has been submitted. Ground C, departure from traditional zoning purposes. Mr. Bryant, would you like to speak to ground C?
Yes, ma'am.
I'll remind you, you're under oath.
As related in my written submission with the protest, most of the time when we look at municipal zoning regulations, and even when we review the intent of our chapter 16 zoning code, it really is to deal with traffic, density of buildings, environmental impacts, infrastructure capacity, noise, structural intensity, or compatibility of physical land uses. It's my feeling that prohibiting what have been permissible business actions based upon the race or immigration status of folks involved in the facility out there fall well outside the scope of chapter 16 intent. Thank you.
Thank you. Ms. Connell? You're under oath.
Traditional zoning purposes is not a legal standard in a protest hearing. Zoning often distinguishes uses by operator, clientele, or function. The initiative is a text amendment which need not address traffic, noise, or density.
Thank you, Ms. Connell. Mr. Connell?
Thank you.
Thank you, sir. Ground C is submitted. Ground D, federal preemption and intergovernmental immunity. Mr. Bryant, would you like to speak to ground D?
Thank you.
Under oath?
So in addition to the written commentary in my protest, I certainly don't claim to possess the final answer to this topic, nor do I expect you as the deputy clerk to issue such. My concern is that similar efforts in states such as California and New Jersey have generated extensive litigation, both involving Core Civic and a lichen company named the Geo Group. And these have raised substantial preemption concerns. I would refer the hearing judge to the Geo Group versus Newsom, which was heard through the Ninth Circuit Court of Appeals. And of course, take note that these were state initiatives with much greater resources than the small municipality of Walsenburg, and they were found invalid. I'm certainly not asking the city to relitigate those cases today. I'm simply suggesting that their existence demonstrates that these issues are not hypothetical, that there has been some settlement that may work contrary to the desired path that the petitioners are requesting, and such deserves a very careful consideration. That I'll yield my time. Thank you.
Thank you, sir. Lakota Connell? Sorry, I keep mispronouncing.
Preemption and immunity are constitutional questions, not protest grounds. Ordinance regulates land use, not federal immigration policy. Local zoning may regulate private or state detention facilities, even if they house federal detainees. And if we're citing case law, Margolis versus District Court 638, page 2D 297, Colorado 1981, pre-election constitutional review is improper.
Thank you, Ms. Connell. Oh, I'm sorry. Okay, and Mr. Connell, do you wish to reply?
I have nothing to add.
Okay, and for ground C, I did not?
No.
Mr. Bryant, did you wish to, or I missed, which did I miss? Daniel?
You forgot to ask Mr. Bryant if you want to-
Oh, yes. Did you wish to reply to the ground C? I'm sorry, I did not give you an opportunity to reply before I submitted it.
Nor do I have any retort to
Okay.
the most recent.
Thank you, sir. I'm sorry about that. And Mr. Connell, did you wish to reply to the federal preemption? And Mr. Bryant, would you like to reply to Ms. Canal?
No, ma'am.
Excellent. Ground D is submitted. And we'll go on to ground E, elimination of special use permit authority. Mr. Bryant, ground E, would you like to address that
Yes, ma'am.
under oath? Thank you.
I have nothing further to add beyond that reflected in my protest. Thank you.
Thank you, sir. Ms. Cannell, would you like to reply to Mr. Bryant? I'll remind you, you're under oath.
Eliminating special use authority is a legislative choice fully within initiative power. Zoning amendments routinely remove or modify special use processes. This is a policy disagreement, not sufficiency issue. And that's all I have to add.
Thanks, Ms. Connell. Mr. Connell, no? Mr. Bryant, did you have anything? Ground E is submitted into the record. We have ground F, downzoning, vested rights, and regulatory takings. Mr. Bryant, would you like to speak on ground F?
Yes, ma'am, briefly.
I'll remind you, you're under oath.
In addition to my written comments concerning ground F, for the record, I would also like the city to consider if the city has evaluated whether prohibiting a previously authorized use could create compensation or litigation exposure. Additionally, does the ordinance affect an existing lawful use in a manner that creates property right concerns? With that, I'll yield my time. Thank you.
Thank you. Ms. Cannell? I'll remind you, you're under oath.
Thank you. Takings and vested rights claims are not protest grounds. Property owners have no vested right in zoning classification. Non-conforming uses are normal in zoning, or non-conforming uses are normal in zoning. And that's all I have.
Thank you. Mr. Cannell? Sir, Mr. Bryant, would you like to address that again?
No, ma'am.
In that case, ground F is submitted into the record. And we'll go on to ground G, extraordinary litigation exposure. Mr. Bryant?
Yes.
I'll remind you, you're under oath.
This is perhaps the most concerning and strangely enough, actually a point of alignment between myself and the protesters as it relates to the understanding and the position that you've taken as hearing clerk as far as not trying to adjudicate these what are clearly legal matters. With that being said, I had prepared a statement for this particular section, and for the sake of expedience, I'll go ahead and read that now. I want to emphasize that this protest is not directed at the public's right to petition their government, nor is it directed at the motivations of the petition proponents or their supporters. The initiative process is an important component of local self-government. My concern is a different one. When a measure is presented to voters, those voters should be able to have confidence that the measure is sufficiently clear, legally supportable, and capable of practical implementation if approved. The questions identified in this protest are not intended to prevent public participation. Rather, they are intended to ensure that voters are not asked to approve a measure whose practical operation, enforcement, and administration opposes the policy objective is a separate question. My concern is whether the measure, as drafted, provides the city and the public with sufficient clarity regarding how that objective would actually be carried out. Now, concerning the issues related to legal review that were communicated to be outside of the scope of the review today, given the complexity of those issues identified in the protest, I respectfully note that CRS 3111-110, the same statute that governs this proceeding today, contemplates prompt district court review of petition sufficiency determinations upon application of the protester, petition proponents, or the municipality. My purpose in raising that provision is not to suggest a particular outcome, but to emphasize the importance of a clear and well-developed record. Regardless of the determination reached today, I believe it is important that the city's findings clearly address the issues presented so that any subsequent review, if sought by any party, may proceed on a complete understanding of the city's reasoning. Once certified, and this is important, ordinance becomes an operative law or liability of the city, and any ambiguity in the terms will fall to the city to interpret and administer, not the petitioners. And by extension, the city, the taxpayers, if I might add. This, of course, is potentially subject to judicial review through the mechanism that I just described in CRS 31-11-110. For that reason, clarity at the drafting stage is important so that voters understand how the measure will function in practice, if at all. Now, I certainly appreciate the time that you all have permitted today and allowed me to bear my testimony. And as stated earlier, my purpose is to not resolve these questions today, but to ensure they are recognized, considered, and addressed in the city's findings. My questions go directly to the ordinance's clarity and how the city would implement and enforce consistently, thus being within the broad scope of sufficiency review. Careful review of these issues does not weaken the initiative process. It strengthens public confidence that measures submitted to voters are clear, workable, and capable of being implemented as written. A thorough review, including administrative, like you all will be performing in the next 5 days, and possible judicial review should the city deem it necessary and as allowed by 31-11-110 prior to city certification ensures that the city and its taxpayers are not shouldered with the expensive burden of litigation. The citizens should not have to litigate this topic on behalf of the petitioners. Rather, the petitioners should resolve the legal discrepancies outlined here today so that not only are taxpayers spared from assuming this burden, but also so that supporters of the measure are not relying upon an unrealistic and unachievable ordinance. The petitioners themselves have recognized today and in the motion to dismiss that elements of their draft ordinance will require such judicial discretion. We also must contend with the fact that upon certification, and this effectively being owned by the city, no longer being in the hands of the petitioners, no less than 3 different groups would have standing to legally challenge the city and this ordinance that they might possibly inherit. Those, of course, being the citizens of Walsenburg, Core Civic, and the federal government itself. City resources and time are better directed towards the numerous other issues that citizens have identified and have requested their city officials to address. Once again, regardless of the outcome, I respectfully request that the city's findings and rationale be stated as clearly as possible for the benefit of all parties, the general public, and possible subsequent review by appropriate third parties as provided by law. With that, I'll yield my time. Thank you.
Thank you, sir. Ms. Connell? And you're under oath?
I'm just responding to that specifically, not my closing statement, correct?
Oh, that's correct.
Litigation risk is not a protest ground. Every zoning amendment carries litigation risk. The greatest risk is actually wrongfully blocked.
Mr. Cannell?
Nothing to add.
Thank you, sir. Mr. Bryant? You're under oath?
And I would submit to your honor that that ability to seek a sufficiency review by district court as provided in 31-11-110 can take place whether you certify the petition in favor or not. By my view, that's somewhat of a, especially given the topics that have clearly been communicated that are outside of the scope of review today, that allows the city to exercise their due diligence. They can provide a product then to the citizens, regardless of your decision to uphold the protest or certify the initiative. It demonstrates that these concerns that are not just my own, but are an aggregation of those that I've heard in the community are addressed, and the city,
Excuse me.
with whatever position that they may choose, is in a defensible and rational position. With that, I'll yield my time. Thank you, ma'am.
Thank you, sir. And I would find that ground G is submitted. And now we're closing the record. Argument and testimony have been received on the Connell's motion and on all 7 of Mr. Bryant's protest grounds. Before I close the record, I will ask each party if they have anything further to add. Ms. Connell?
Mr. Bryant clearly states in his introduction that the protest is limited solely to legal sufficiency of the proposed initiative, integrity of the municipal ballot process, obligation to measures, compliance, efficiency of the initiative is not in question, nor is the integrity of the ballot process. The only question is which legal and procedural standards are applicable. Jusdem generis rule, not limited to, means additional grounds must be of the same kind as the listed petition form and affidavit defects, not constitutional or policy arguments. In other words, limited initiative rights must be in favor of ballot access. The deputy clerk, that was under Bruce versus City of Colorado Springs. Deputy clerk cannot expand initiative restrictions beyond what the statute expressly provides. That's under the Committee for Better Healthcare versus Meyer, and has no discretion to block initiatives based on policy or constitutionality. Versus City of Louisville. Pre-election constitutional review is improper, and the term not limited to cannot deny ballot access based on policy disagreements. City of Inglewood versus Save the Park. Mr. Bryant has produced a lengthy list of his concerns, but not a single valid argument for stopping this initiative from being placed on the ballot. Thank you.
Thank you, Ms. Connell. Mr. Connell? I'll remind you that you're under oath.
Mr. Bryant asked the clerk to declare the petition legally insufficient, block ballot access, issue judicial style findings, and grant additional relief. CRS 31-11-106 and 31-11-1010. The intent of the statute is clear. A complaint should not conduct constitutional review, evaluate zoning policy, assess block initiative based on preemption, takings, or vagueness, or deny ballot access for non-Article 11 reasons. Granting the relief requested would exceed the clerk's statutory authority, ultra vires, and violate the ministerial nature of the sufficiency review. For the reasons stated, petition proponents respectfully request the acting deputy city clerk grant the motion to dismiss the protest in its entirety for failure to allege any valid Article 11 defect and allow the petition to proceed to signature sufficiency review and ballot certification as required by law. Thank you.
Thank you, Mr. Connell. Mr. Bryant, anything further for the record?
Yes, ma'am.
Concerning the statements that no specific issues have been cited here that are within the purview of this hearing, I would contend that the administratability of the correct language of 31-11-110 as far as allowing the not just limited to provision in there, as the petitioners would have it, any sort of sufficiency view would only really revolve around the signatures themselves. If that were the case, then it seems very unreasonable that by the city upon certification and this no longer being a ballot measure by the petitioners, independent ballot initiative, it then becomes that of the city. And if it's unworkable and unfeasible, and rather than laymen like myself and the Canals, with all due respect, trying to litigate this matter and rehearse different legal texts that we might have come across. I think this really illustrates the point that much more, that regardless of your decision in the hearing, that the city seeks that judicial review mechanism that's provided in 31-11-110. With that, I'll yield my time. Thank you, ma'am.
Thank you, Mr. Bryant. Ms. Connell, anything else for the record?
I would just like to say that the whole point of this was to let the voters decide. And I think that should be honored because the public has spoken and they want to say. Thank you.
Thank you, Ms. Connell. Mr. Connell, anything further?
Thank you.
Thank you, sir. The record in this matter is now closed. No additional materials, documents, or testimony will be accepted after the close of this hearing, absent extraordinary circumstances and my expressed written authorization. I will issue a written ruling resolving both the motion and the protest on the merits within 5 calendar days of today's date, as required by CRS 31-11-110. And the ruling will be certified for both parties at your addresses of record. I want to advise both parties following my written ruling, either party or the municipality may seek district court review of the sufficiency determination of in the district court for Huerfano County under CRS 31-11-110-3. The statute requires that such review be sought and determined promptly. Are there any procedural questions before I adjourn?
Will we get an email notification?
In addition to having it certified to your address. And I would like to thank both parties for the extensive research and time and energy spent. I think it serves the community well to have these types of things, and your both parties are obviously dedicated to their thought, and I appreciate you so much. Thank you. If there are no questions, no additional questions, hearing none, this motion is adjourned. The time is 1:53 p.m. All right. Oh my God, I thought I was going to cough myself to death. I couldn't have done it without. Thanks, sir. No, thank you so much. I appreciate you. It's nice of him to come. Oh, yeah. Don't click on anything, Rosie. Yeah, just leave everything in. We're just going to let it run for a second. Now we have E. Our purposes are so movie star Dan. We need.
Yeah, as long as you're not gonna use it for any commercial purpose, right? I'll give you 5 days. I beg you to go quicker.
Yes, I would like to go quicker.
It won't make next Thursday's paper if you usually.
I will do what I can. Yeah, well, and what let me know was that I don't have to keep counting the vote. So
You want to get a picture? We're going to stand.
okay, hang on, because I'm not done yet.
I can't.
Oh,
Please. This is Soco Grove.
that's almost like a victory lap.
Station, that's all. Just like we memorialize everything.
Now this is the impact. Okay, so all we had it was. Yeah.
Can we get a picture? I gotta finish this.
Remember you, darling?
They're gonna sign them.
Let's go up here for a picture. Just can't use my picture in a way that.
Oh, no.
Or.
No.
yes.
Looks like they muted up. I don't know. What do you think about that, John? I think we lost John. That's all right. Yeah, so this was basically basically a hearing on the use of the prison facility near Walsenburg. They're trying to protest the fact of ICE using the facility. The gentleman that was speaking in the blue shirt wants the facility to be used for ICE. So basically what's going on is they're trying to put it up to a vote for the people on if it should be used as an ICE facility or not. So that's basically what that was about. I don't know, but I tell you what, thank you everybody for stopping in. Scales, what's going on, bro? We had Lacey R, we had Brandon, we had Question Everything, we had Anarchy pop in. John looks like he dropped off. So thank you everybody for showing up. Greatly appreciate you. I guess we'll talk to you on the flip side. Have a great day, everybody.